YouTube channel. Today's episode, we'll be talking about estate planning. Estate planning is a very pivotal part of Australian life. However, it is often overlooked. To help us today, we have a great expert with us today, Nicole Curie from Curie Scott Associates. Thank you, Nicole, for coming.
Thanks, Sharon. Thanks for having me.
And to help us in terms of the flow of the episode, we have Henry from Bentley's Accounting.
Pleasure to be here. Well, as Sharon mentioned, estate planning is a very big part of Australian life, or in life in general. Now, Nicole, just for our viewers' sake, can you explain what is estate planning?
Yeah, sure. So what estate planning is it's the collaborative term which refers to wills, powers of attorney, and advance health directives. So it encompasses all three of those very, very important parts of your planning.
That's quite interesting. Look, why is all these three that important?
So the reason we have estate planning is what it does is it effectively protects you while you're alive, and it protects your assets once you pass. So the will covers you from your date of death onwards. It covers all your assets and who you want your assets to go to. Whereas the enduring power of attorney, or even a general power of attorney, or an advance health directive covers you personally while you're alive. As soon as you pass away, they no longer effective.
You mentioned three things in there that I find quite fascinating, really. Wills, which I'm sure is the most common one, power of attorneys, and advanced health directives. You mentioned how each of them play in your daily life, but could you provide a bit more detail regarding all three?
And I'm sure all of you have heard of at least a will, although the majority of people, I'd be very, very sad to say that the majority of people don't actually have a will in place. But I'll start with that because most people know what that is. Effectively, what a will is, it documents your wishes in terms of your personal assets. So anything held in your name personally, so whether it's property, bank accounts, superannuation, if you don't have any death benefits, nominations in place, any jewelry you might have, or any heirlooms you may have, or any things that you use for specific hobbies which are close to your heart, your motor vehicles, and those sorts of things. So basically anything in your name personally. So that's where you get the opportunity to give those assets to family members and loved ones. Quite importantly as well is your will is a tool where you can take people out of your will. You can exclude them. If you've had a falling out with a family member, you can exclude them. There are consequences of the exclusion, which you'll get proper advice on, and then you can decide how you want to go with that. But you can still do that. There is place for that. Your will also covers things like if you've got children under the age of 18, who's going to be their guardians. As well as, you get to nominate somebody to manage your estate. So that would be your executor. So what that person does is they take your will, they look at it, they get advice from your accountant and your lawyer, and they say, okay, this is what the person wanted. And from there, what they'll do is they'll actually go ahead and administer the estate in accordance with your wishes. Whether it's, your children are only to receive their inheritance at X age, whether, your family home is not to be sold immediately, whether it needs to be rented out, and they actually oversee all of that. So that's the point of having your will. In the short version is to ensure that what you want to happen with your assets and guardians of your children and things is actually put into place. Without that, we have a problem.
One thing probably a lot of the viewers might mistake is if they own a business or they have shares of various things through a family trust, which is a lot common in the Australian society, which is you hold shares in a family trust. That's probably what we very advocate with our clients. But those, if it's in a family trust, but then what happens? Because I understand a lot of the commercial assets aren't really included in a will.
Yes, no, that's correct, Sharon. So anything held within a trust or via a company, you can't actually gift within your will. What you can do is you can have your executor nominated to step in as director and deal with your business. You can nominate your director to step in as trustee and deal with your trust assets. But effectively, where this comes into play is where you'd actually need to have a chat to yourself and make sure that your shareholders agreements are, there's an estate plan within your shareholders agreements, within your constitution of your company, and to ensure that that is all aligned with your will. Because if there's any inconsistencies within your trust, your company, and your personal assets, if someone is wanting to contest your will, there's a high chance that they'll find loopholes within all of those. What were your actual wishes? Your will says one thing, the trust says another, the constitution says another, and your superannuation death benefit says something completely different. So that's why you need to have a panel of lawyers and accountants to oversee all of this to ensure that everything's consistent.
Yeah, especially for commercial clients, definitely my role is make sure that estate planning is formed part of the general documents, as you mentioned, shareholders agreement, constitution, or even in the trust deed, so that's very consistent. But more important is if you do appoint a wills and estate attorney, you have to let me know as your commercial lawyer, because we have to make sure, as Nicole said, it's consistent with your will as well, and that way we know there is a real form. So in the event you should pass away for unforeseen circumstances, we're prepared and we're able to liaise very quickly to make sure that your wishes are actually done in accordance to your
will. Yeah, no, definitely. And there's lots of different types of wills that you can have, whether it's a standard will, testamentary trust will, special disability will. There's lots of different wills you can have done, just dependent on your circumstances. And you really do need to get the proper legal advice to ensure that the will that's made is a will that is for you.
It is almost like a will must be custom made to your specific situation, because look, as an accountant, and I'm sure Sharon as a lawyer, there is no one person is very unique to itself. There is no exact same situation, even if you are twins, that it applies exactly the same way.
That's exactly right, Henry, and that's why your sort of stock standard post office wills, people tend to use it because it's a cheaper option to go, and they think they know what they're doing with it. But generally, those they don't really work. There's so many issues when it comes to forming the will, putting it together, validity. If there's no consistency within it, if you don't have an expert putting all that information together for you in a customized will, your family will have a whole heap of trouble upon your passing. So what I do with my wills as well is I prepare something called a Memorandum of Wishes. And what that Memorandum of Wishes is, it's not legally binding. It's just a separate document which gives your executor the direction as to where to go with your will. So, for example, if you gift all of your jewelry to all of your children, you may have 100 items of different pieces of jewelry, and there's no space, and it's not practical to put every single item in the will, but ultimately your wishes are that they to go to the children. Whereas in your Memorandum of Wishes, although it's not legally binding, it guides your executor and gives them an idea as to who gets what type of pieces, and how many each one is due to get, and those sorts of things. And we recommend that you update that Memorandum of Wishes at each juncture. Each time something changes, you buy a piece of jewelry, you sell a piece of jewelry, what you want to sort of happen with your business as well, if your executor is to step in as director of your company and those things, and that can just get updated. With your powers of attorney, now that is something very different. A lot of people mistake your executor and your power of attorney and those documents as one when they're completely separate, although they're both equally as important.
I was going to say that it is, for a non-lawyer such as myself, it all sounds exactly the same in regards to whether it be a will, power of attorney, or whatever else it may be. Give us more detail regarding what does each one do?
So, like we were saying, a lot of people blur all the concepts into one, and they don't actually know the difference. They use the words executor and attorney interchangeably when it's actually not the case. So, like I was saying previously, your enduring power of attorney is only valid while you're alive, as well as your general power of attorney. As soon as you pass away, the people you've nominated as your attorneys can no longer act. It's illegal for them
interesting.
to act, to have access to your funds and things like that. So with your enduring power of attorney, that covers making decisions for you for financial matters and personal health matters. So the financial side of it means that your attorney can actually go into your bank, take money out of your bank accounts, pay rates, pay your bond, deal with Centrelink, deal with Medicare, do the groceries, and those things. You can nominate when that power starts. So that power can start immediately. So as soon as your power of attorney is signed, that person can go and have access to your bank accounts and do what they need to do. Whereas the enduring side of it is your personal health. Okay, although it's ingrained in one document, it's separate powers that they have. Now, the enduring side of it deals with going and making decisions about turning off life support, putting you into a nursing home, deciding where you're going to live. Now, the difference between the enduring side of it and the finances is that the enduring side of it will only commence upon you losing capacity to make decisions for yourself. And only a doctor can determine that you've done that. So in order for the attorney to act in that role, they'll need a letter from a doctor to say that you cannot make decisions for yourself, whether it be via old age, Alzheimer's or dementia, or whether it be by, a car accident and you're in a coma, or, you're not lucid for a period of time. During that period of time, they can make decisions for you. And it's quite important to have that in place. What's equally important with a power of attorney, whether it's enduring power of attorney or general power of attorney, is that the people you nominate as your attorneys to make decisions for you are people that you trust.
So it doesn't have to be, say, a lawyer, but it can be someone, a family member perhaps.
A lot of people choose family members. So you can choose your lawyer or your accountant, but you just need to be aware that as your lawyer and your accountant, they can charge to make those decisions.
Yep.
And a lot of the time, you wouldn't want to have your lawyer or your accountant making decisions about your personal health, unless you've got no one to do it.
Or unless it's for commercial purposes, which a lot of my clients do give in terms of do property settlement or entering into a deal or finalising a deal.
Exactly.
Then often general power of attorneys will give in to the lawyer or their agent or their employee to act on their behalf.
Yeah, exactly right. Your attorneys have to abide by Powers of Attorney Act, so there's legislation that governs them, but at the same time, it's a very big headache trying and enforce that's the legislation on people that aren't doing the right thing. Advanced Health Directive. So this one's not very, very commonly spoken about, but it is out there. So what an Advanced Health Directive is, it needs to work alongside your enduring power of attorney. So it can't work alongside your just a general power of attorney. It has to be enduring power of attorney, because what comes into play is the enduring and personal power that your attorney has, okay? So in order to enact the Advanced Health Directive, your attorney needs to have the power by an enduring power of attorney. So what will happen is we will draft up the bare bones of the document, which includes questions about your medical needs, medication, whether you want life support turned off, if you want sort of an end of life plan, if you want certain antibiotics, you don't want antibiotics, you don't want pain relief, or you do want pain relief, and those sorts of things if it comes to time when they need to use it. And what will happen is then I'll send you off to your doctor. Your doctor will go through all those things with you and give you advice on your wishes, sign off that they are satisfied. Then they will come back to myself and I'll go through the document, make sure you're happy. We'll get it all signed up, make sure that it's all legal, and then that just sits with your enduring power of attorney just in case your attorney needs to use it. And it's a very, very handy tool to have in place because, a lot of the time your attorneys are your loved ones. Okay, and your loved ones don't know a lot of the time what your wishes are in terms of turning off life support especially, and if they during a stressful time where their loved one's in pain and they're not lucid need to make that decision, it's a very hard call to turn off the machine.
It's interesting that a lot of the times when clients do, come to face with advanced health directives is when they're at hospitals. So due to unforeseen circumstances, you may end up in a hospital in a coma, or you need emergency medical procedures, and the doctors will definitely put a advanced health directive in front of you, and if it's your family, that's fine. But there are studies that show that, for example, that husbands are more likely to not resuscitate you or, make drastic decisions to turn off your life support. Whereas, your next of kin, your actual mother, maternal mother or sister are more likely to ensure that you are given that life support as much as you can, and then make an informed decision to turn it off if it's really necessary.
On the other hand, Sharon, as well, is if you don't have something like that in place and they have to make those decisions, whether it be your husband or your parents or any sort of siblings or anything, if you don't have that in place and they've got to make that decision, it's a hard decision, and it makes it a lot easier for them to have a piece of paper to know, okay, this is what they wanted. Whereas if they have to make that decision themselves, they've got to live with that decision for the rest of their life.
Thank you very much for that, Nicole. That has been quite detailed in your explanation and quite enlightening, I would say, is the right word. Now, to put all of this into perspective, I understand you've prepared some examples on how and where these might apply.
I had a gentleman in his 60s come to me just to talk about wills generally, because he was looking at getting a will done. He never had a will, and he had a lot of assets, lots of cash under the bed, very old school.
Very traditional.
Very traditional. He had lots of property, lots of things to his name personally. Did not have a will. His wife passed away quite some time before, and he only had one child. Okay, so his daughter was I believe she was in her late 30s, only child, and he lived on quite a large property and had a granny flat at the back, and he rented it out to a female friend. So
a female friend,
and he assured me that she was just a friend. And so we discussed the wills, the importance of having a will and what means if you don't have a will, as well as, I questioned him about this female friend to see whether she would, possibly try and contest and things like that. So we went through all of that. He still didn't want to give me formal instructions. But I was concerned because he came to me. From then on, it's my obligation to ensure that he's covered until he comes back and gives me formal instructions and signs a formal will. So what I did is I went through and wrote down just informally his wishes. I wrote down detailed reasons as to how this female was just a friend and nothing more, and they did not have any sort of relationship, and that how he wanted his entire estate to go to his daughter. We discussed that. He signed it. We had 2 independent witnesses, which is required for a will, and I just held on to that. And then what had happened is 2 weeks later, I got a call from his daughter to say that he passed away. Ooh. He did not mention to me that he had aggressive cancer. So that was a big concern. So because I had prepared this document that he signed with his wishes, I was able to get that document through probate, which is through the court, to confirm that this was his last will before he passed away. There was, the moral of the story really was, it was costly to get it through the courts. Even though there was something on paper, it wasn't considered, obviously a proper will. There was lots of exceptions, and we had to go backwards and forwards with the courts to ensure that it was sealed properly. But there was costs involved. His daughter was emotional at the loss of her father. She had to deal with that. Then we had to deal with the female friend trying to contest.
Just for out of interest purposes, this person A, situation A, normally, if the female friend didn't exist, I am guessing everything would have gone through to the daughter much more smoothly.
No. So it would have gone a little bit smoother because she did try to contest, but we still had to go through the court process. You know that she called me the day after he passed away to ask me what she was receiving? Dearie me. So that's
quite interesting.
This is why we have a will. So yes, that was quite a unexpected phone call.
Buying peace of mind indeed. I mean,
yeah.
For those who don't know, I am an accountant, so I will state this. How much value do you put on that?
Exactly. Exactly right. So yes, that was a very interesting case and one that I'll remember forever.
Interesting.
Yeah.
Especially in the Asian community where wills and estate planning really isn't a key issue. It's not seen as a priority. So a lot of times husband and wife will come here and migrate, they get into businesses, they have superannuation funds, or they will do their respective works. Tragically, one of them dies, or maybe both of them die. And usually then they come to me because they're fighting against the state, which they don't realize. For your information, some countries around the world, generally if your family dies, the next family, the wife or the kids, are automatically is in line for your assets. But unfortunately in Australia, that's not the case.
No.
So they come into a rude awakening that they're fighting against the state, they're fighting against the superannuation fund, because unfortunately death beneficiary haven't been nominated by the person, so they have to validate that they have the right to the access to the superannuation fund, which is tragic.
This is despite being the next of kin.
Yes.
Despite the next of kin, or whether the child of the deceased, so it could be the father and the mother may have died, and the kids are quite young and they need living expenses, but they can't get access to the parents' superannuation fund. And I don't know what your sort of advice is in terms of case B.
Ultimately, a lot of people don't know that they need their death benefit nominations in place firstly. So that is something definitely to remember, to have your death benefit nominations always up to date. The other thing to know about those nominations is that most of them lapse every 3 years. So they need to get updated every 3 years, unless you're lucky enough to have a non-lapsing binding death nomination, and then they don't actually lapse until you change it. So that's important to keep that in mind. The other thing is have a will. Regardless, it's whether you have $1 in the bank or $5 million in the bank. If you don't have a will in place, it just makes life very, very difficult for your loved ones upon your passing. And then once legislation comes in terms of the Succession Act on how your assets are to be distributed, which will happen if you die without a will, you might have somebody in there in accordance with the legislation that you don't actually want to receive any part of your assets.
Most people, I would also say, don't like thinking about death, I'd say, is almost a...
That is very true, Henry. Very, very true. I must say that the majority of my clients come to me, especially when they are a couple. One part of the couple is dragging the other to come because they don't actually want to deal with their mortality, and they don't want to deal with the fact that, yes, you are going to die at some point in your life.
How about for young couples? Do they need?
So, yes, so Henry, that actually brings us to case number C.
Okay.
The third case I want to discuss with you is actually a young couple. They just got married, went on honeymoon and passed away.
On their honeymoon?
On honeymoon.
Interesting.
Yeah, so they both drowned.
Oh, yeah.
So that wasn't very, very good. They went scuba diving and there was a few issues. So basically that's what happened to them. But I'll just rewind back 2 years before that. When they were dating, they first started dating, they both came to me to give me instructions for their wills. They gave me separate instructions because they had completely separate wishes and I was required to see them separately. But all in all, I did the wills for them, we prepared them, we got them signed, and we put them away. Just on a side note, neither of them told me of their intention to possibly get married in the future, which I'm sure at the time wasn't relevant because they just started dating. However, the issue with having a will done before you get married and then getting married and passing away without updating your will after you get married is that marriage revokes a will.
Can you just repeat that for the viewers?
Yes, that's correct. You heard correct. Marriage revokes a will. So if you prepare a will while you're single, as soon as you get married, your will is automatically revoked. So I know it's not practical for couples to go straight from the registry office to their lawyer to get their will done. I think they want to have a bit of a celebration first.
I think that's the least romantic event that could happen in your wedding day.
Exactly. So what I do is I like to encourage my clients, if I know that there's a possibility that they might be getting married, to let me know. And what we do is we actually make the will in contemplation of marriage.
Oh, wow.
So even if it's before they get married, we make the will in contemplation of marriage, then it does not automatically revoke.
So you can get, almost say, around that automatic revocation
Exactly.
at the time of marriage.
Exactly. So, but you need to let me know. And those are the questions I will always ask, but it's a good thing to keep that in the back of your mind. Is marriage automatically revokes your will? So what happened with this young couple is that their families went off separately and had to apply to the court for letters of administration, where the court will appoint an administrator who's applied either, a loved one, and effectively your administrator is the same role as your executor would be in your will. And then the court determines where exactly your assets go. So the outcome of that story was her family received the entirety of her assets and his family received the entirety of his assets.
I can imagine a lot of viewers having a panic attack at the moment from getting
Yes.
married and be thinking, oh, I drafted a will, I thought I'm protected
Nope.
because I don't want my spouse to get anything. There are alternative ways to protect your assets through owning financial agreements or other means. If your spouse is not willing to sign binding financial agreements, which usually does happen, there are alternative ways. Either you need to talk to a family lawyer or myself, commercial lawyers, where we can do it commercially as well. So yeah, I guess that's something very important. You and me and Henry, we're all professionals. So basically, we understand the importance of documentations and having things in place. What I found with a lot of clients is, especially the younger clients, is they feel like, oh, I don't have anything. Why should I do estate planning now? What is your answer to that?
So in short, my answer to that is you need to have your estate planning in place regardless whether you have, like I was saying, $1 or $1 million in the bank. You've always got something to give. And if you don't have a valid will in place, what will happen is then you're going to have to deal with the state. We're going to have to deal with the courts. We're going to have to deal with legislation and people possibly receiving assets of yours that you don't want them to have. Plus, on top of that, putting emotional and financial strain on your loved ones. And there are a lot of blended families, especially in Australia, and this is something that's very real and something we deal with quite often. So it's very, very important to have a will in place. If this is your second marriage, if you're looking after children, your wife's children or your husband's children as well, and you specifically don't want them included, we need to specifically put measures in place to protect your assets upon your death. However, there are different risks involved in excluding these people from your will, which we will discuss. So you'll be aware of what could happen. And their right to contest based on their status in your life. But if you don't have something in place, it's going to be a lot easier for them to make a claim.
I guess in summary, to make it easier, just to clean it up a bit for the viewers, it's important to have an understanding that wills are important whether you're young or old. Number 2 point will be is make sure you have a full disclosure in terms of all your personal circumstances. In terms of advanced health directives, as you said, is to give specific instructions. Do you want your organs to be donated or not? Do you want certain people to have power? Because from my memory, you can both appoint your husband and your mother to be your
That's
interim
correct.
power of attorneys. So it really gives a lot of food for thought for the clients in terms of not only their financial but their personal and health circumstances, and then come to you with regards to that. If you intend to get married, let them know.
Divorced as well.
Divorce as well. If you intend for probably a third party that's not really your immediate family to receive an asset, make that be known.
Definitely.
And then the fourth thing will be is transparency to your lawyer. Just make sure everything.
And don't be embarrassed to say anything that even if you think it's not relevant, we see anything and everything. So for us, we appreciate receiving all information. There is nothing that's useless. And if you're an MYG client, then Sharon will have a lot of that information as well. So her and I, obviously with your consent, would discuss your situation to ensure that I've got the whole picture, to ensure that whatever I'm drafting is 100% tailored to your circumstance and is completely relevant to you, because that's the most important thing.
How much would all of this cost?
Yes, okay. So for costs, I can't give you a specific amount, but I can give you a range because the specific amounts are determined by your personal circumstances. But effectively, I like to recommend that because I'm an advocate of having your whole package put together, which is your will, a standard will, an enduring power of attorney, or a general power of attorney, and an advance health directive. I like to bundle it together so you're completely secure. So the cost for that is between $800 and $1,500. And then I like to provide a further incentive to my clients where if you are in a relationship, whether it's a de facto or you are married and you've got a spouse and you both want to come in to give me instructions for your wills, there's a further reduction in price. And then those range between $900 and $1,800. Testamentary trusts are a little bit more, but that I actually have to quote you on a case-by-case basis because there are a lot of factors that come into play with that. But ultimately, whatever I quote you, it's going to be a fixed fee, and we never deviate off that. So you'll always know upfront what you're paying.
Why should they come to you?
Why should they come to me instead of all the other estate planning lawyers in
Correct.
Brisbane? Yes, okay. So my point of difference is communication. Communication from beginning to end. If I'm dealing with a matter with Sharon, it's collaboration with her to ensure that we actually encompassing your whole situation. If you've got an accountant like Henry, dealing with Henry, making sure that we've got all your assets all put together to make sure that's also sorted. The other point of difference is that you'll be dealing with me. I won't be palming you off to a junior to do the work for you. You'll be dealing directly with me from A to Z, and you'll always get I'll always go the extra mile for my clients to make sure that you are protected and you're looked after.
Nicole's very in line with how we work. She's very attention to detail. She makes sure that the prices are fair, top law firm quality at a fraction of the price, which is very reflective of what MYG Legal is.
Yep.
And hence why we work very closely with Nicole for it. I can definitely say, based on my experience with Nicole, the quality that you will receive is worth every dollar that you pay her with regards to that.
Thanks, Sharon.
Thanks everyone for watching our episode. I hope you find it very informative, and I hope you're rushing towards your phone to call Nicole to start your estate planning. Please subscribe to our YouTube channel and stay informed and get great information.